Hello, this is Robert Larson. I'm an attorney and the owner of the Larson Law Office in Mesa, Arizona. And over the years, I've represented hundreds of people in family court cases. And I've had a few cases recently that have reminded me that when someone gets a restraining order against them, it has a huge impact on your case in family court. And so there's a few things I wanted to talk about when it comes to restraining orders. So first of all, I just want to define what a restraining order is. In Arizona, typically that's going to be either an order of protection or an injunction against harassment. So what's the difference between the two? Well, an order of protection is a restraining order that someone gets against you, or you could get it against someone else, and it involves a family member. So someone you're related to, or someone you've had a romantic relationship with, or you have children in common. It could even just be someone that you live in the same home with, but there's some kind of family relationship there. An injunction against harassment is basically non-family. It could be neighbors who are complaining about harassment, or it could be some kind of workplace harassment, or someone's complaining about online harassment. It could be just about anyone. So it's an oversimplification, but basically an order of protection is for a family member or someone with a family relationship, and an injunction against harassment is everyone else. Either way, if you get a restraining order against you, it's going to tell you that there are certain things you can or can't do. So the main part of the restraining order is that you can't contact the person who's listed on there. And it could be just the person who applied for it, but it could also include other people. So for example, if it's the mother or father of your children, it could include them, and it could include your children as well. So that can make a major difference in your ability to have a relationship with your children. So it's a pretty big deal. But it's also going to include often other people who live in the home. So there may even be people who aren't related to you listed on there if they live in the same home as the person who got the restraining order. It's usually going to include the places where they work and go to school and things like that. So there's some pretty serious restrictions, because if you violate those, then you could be arrested, and if it's an order of protection, you could even be charged with a domestic violence offense for violating that order. So it's a big deal, and it has a major impact, especially if you have a family court case going on at the same time, such as a divorce involving children or a custody case that you're going through. It's going to have a major impact on that case. And so that's one of the main reasons I wanted to talk about that today. First of all, you should talk with an attorney if you get any restraining order served against you. A lot of times people look at it and they think they understand what it means. But these restraining orders are written in a way that they're confusing and often not very clear. So I've talked to a lot of people who've had restraining orders, and almost everyone misunderstands at least one part of it, if most of the time more than one thing. So you want to speak with an attorney and just make sure you understand what your rights are, make sure you understand what you can or can't do, and find out if you need to do anything about it. It's very possible that you don't need to do anything. Sometimes people get a restraining order served on them and they don't want to have any contact with the other person. They don't have any reason to contact the other person, and their rights aren't really restricted that much, and there's really nothing they need to do about it. They can just let it go, and all they have to do is follow the restraining order and not contact the person, and it'll go away in time and not be a big deal. Other times it could be a very big deal. Like I said, it could involve your ability to have contact with your children, and sometimes it prohibits you from even being able to live in your own home. So if you're living with someone, whether it's a spouse or someone else, and they get a restraining order against you, it's going to include an order that you can't be at that home. And if that's where you live, that's a big deal, obviously. And in fact, you can sometimes be served. You could be sitting at home, someone knocks on the door, and the sheriff's deputy serves you with the restraining order and tells you you have to leave. And they might give you 15 minutes to pack up some things, and you're out of there. So sometimes it's a very big deal, and you need to do something about it quickly. But no matter what you do, the first thing you should be doing is talk with an attorney and make a plan first. Often people see on the restraining order, there's a part there where it says you have a right to have a hearing on it. And so in other words, you get to go in front of a judge and contest the allegations and try to get the restraining order dismissed. And so a lot of times people schedule that as soon as they possibly can. And the problem with that is when you request a hearing, they're going to schedule it very quickly. By law, they have to do it within 10 days. And the reason for that is because when someone gets a restraining order against you, they go into the courthouse, they fill out some paperwork, and they talk to a judge immediately. Because in theory, the person is in danger. And if someone's in danger, they need to get protection right away. And essentially that's a violation of due process. Due process says you should have a right to know when someone is making allegations against you and know when someone is trying to do something that could affect your rights. And so you have an opportunity to object and contest the allegations and have your say and basically make your argument to the judge. But if someone's in danger, they will go ahead and allow that violation of due process because the theory is that the person's safety overrides the right to due process. However, they make up for that by saying if you ask for a hearing where you want to contest the order of protection and try to get it dismissed, then they have to schedule it very quickly. So within 10 business days, they will schedule this hearing. And sometimes it's even 6 or 7 days. And so you want to make sure you're prepared before you actually schedule that, because otherwise, if you request a hearing immediately and you're not ready, you're going to go into court and you could lose because you weren't properly prepared. It's also possible, if you speak with an attorney, that the attorney may decide that you're better off dealing with this in the family court. So in other words, combining the cases, whether it's a divorce or a custody case, you might be better off moving the order of protection to the family court and let the family court judge deal with everything together. And the reason for that is because in family court, a judge has a lot of things they have to consider when making decisions about legal decision making and parenting time with children. And they get to look at a lot of things that the order of protection judge doesn't get to look at. And so a lot of times it's better to just combine, and even though it means you might have to wait a little while, usually it's better to just kind of be patient and deal with it all together in the family court. I don't want to get into too many specifics or advise you on your specific case because everything is different. But the main two things that I can say are, one, you should speak with an attorney no matter what, just to make sure you understand your rights. And the second part of it is, if you have a family court case involving children, you should definitely hire an attorney, because if you don't and you go through the order of protection hearing and you lose, it can really affect the outcome of your family court case. And sometimes the judge in the family court, his or her hands might be tied. So they may want to give you reasonable parenting time with your children, and they may want to give you the right to be able to make decisions and be involved with making decisions about your children. But if you lost in the order of protection hearing, they may not be able to do that for you. And so that's why you definitely want to speak with an attorney, make sure your rights are protected, and make good decisions when you get served with a restraining order, and don't just immediately schedule a hearing. So anyway, hopefully that was a little bit helpful, and if you found that helpful, then you can look at the other videos on this channel, subscribe, and I'll talk to you later.